drink. Isn't that right?
Well, I'd say that's pretty typical for a waitress.
And isn't it also typical for a waitress to do that type of lifting many times a workday?
Yes, that's true.
Then, Dr. Feamer, isn't it possible that Ms. Payne could have herniated the disc in her neck due to the repetitive nature of the heavy lifting, and that the herniated disc could have caused the degenerative condition of her neck?
Well, I suppose anything is possible, but I didn't get any sense from Miss Payne that she had been experiencing such severe pain before the accident.
So, Dr. Feamer, what you're simply telling the jury is that you relied entirely on what Ms. Payne chose to tell you regarding the history of her injuries when you determined her medical condition.
Well, every doctor has to rely upon the patient's candor and honesty with respect to the history in determining the cause of an injury. It's the nature of our profession.
Thank you, Doctor. That's all I have, Your Honor.
Plaintiff may call your next witness.
Your Honor, the plaintiff rests her case.
The defendant may call her first witness.
We call Diane Davis to the stand, Your Honor. Diane, would you please introduce yourself to the jury?
My name is Diane Davis. I've lived here all my life, and I'm married and have 2 daughters.
And where do you work?
I'm a checker down at the Walmart. I've been there for 10 years.
Ma'am, where were you going at the time of the accident with Ms. Payne on June 27 of last year?
I was going to work.
And how did the accident happen?
Well, I pulled up and stopped at the red light at the intersection of Main and Avenue A. I was behind the car, but I didn't notice anything about the car until the accident. When the light turned green, I saw the car in front of me start to move, so I put my foot on the gas. Before I knew what was happening, the car in front of me just pulled up and stopped abruptly. I tried to put my foot on the brakes, but I couldn't stop fast enough, so I bumped into the back of the car.
What do you mean by the word bumped?
Well, the collision was just like a tap, like I barely touched it.
Ms. Davis, were you talking on your mobile phone at the time of the accident?
Yes, I was.
And how did that affect your concentration?
Well, I was still paying attention. My car is an automatic, so I only needed one hand on the wheel. It's just that Miss Payne stopped so quickly, I hardly had any time to react.
After you bumped the car in front of you, what happened?
Well, I hung up the phone, I got out of my car and checked to see if there was any damage to my car. There was a small scratch on the front bumper, but not much of one.
And what kind of car were you driving at the time of the accident, Ms. Davis?
It was a Mercury Cougar.
Let me ask you to look at what's been pre-marked as Defendant's Exhibit 1. Your Honor, I believe the plaintiff has already stipulated to the admissibility of this exhibit.
We have, Your Honor.
It's admitted.
May I approach the witness, Your Honor?
You may.
Ms. Davis, would you please describe to the jury Defendant's Exhibit 1?
It's a photograph taken of the front bumper of my car shortly after the accident. As you can see, there wasn't very much damage done to the front of my car.
How would you describe the force of the impact?
It wasn't too hard. When I saw Mrs. Payne's brake light come on, I started to brake. So I guess I was slowing down when I hit her, so that helped to reduce the impact. I don't know why her car got so much damage, even though mine wasn't.
What happened next?
The person in the car that I ran into, who I now know as Patty Payne, was sitting in her car and screaming that her neck hurt. I went to the driver's side of the car and asked her if she was okay. Eventually, she got out of her car.
Did you talk with Miss Payne at that time?
Yes. I told her I was sorry that I bumped into her, but I just didn't think she was going to move that quickly. And I asked her if she was okay. That's all I said.
And what did she say?
She said that she was hurt, but she was able to move around and talk to me.
Did anyone call the police or an ambulance?
No, I was in a hurry to get to work and I was fine, and I didn't feel like we needed to call them. Miss Payne didn't say anything about it either, so we just gave each other our numbers and left.
When was the next time you saw Miss Payne?
When I found out about this lawsuit.
Thanks, Miss Davis. I pass the witness, Your Honor.
Cross-examination.
Yes, Your Honor. Miss Davis, you testified earlier that you were in a hurry. Isn't that true?
Yes, I was trying to get to work.
In fact, you were late, weren't you?
A little bit, but I wasn't that far from work.
At the time of the accident, you were talking on your cell phone, weren't you?
Yes, just to let my supervisor know that I was a little bit late.
And didn't your shift start around 9:30 a.m.?
Yes, it did.
And isn't that the same time that this accident happened?
Yes, sir.
And your cell phone is the kind that you have to hold in your hand. Isn't that correct?
Yes, that's true, but
And even though you were talking on the phone and driving with one hand, you want this jury to believe that you were able to notice that the light was green and that my client started to go and then suddenly stopped?
yes, that's how it happened, sir.
I have no further questions, Your Honor. I pass this witness.
You may step down. Call your next witness.
The defense calls John Smith, Your Honor. Mr. Smith, would you please introduce yourself to the jury?
My name is John Smith. I'm a computer programmer from right here in town.
And where were you at 9:30 a.m. on June 27th of last year?
I went to pick up some donuts for my family at the Tasty Cream Donut Shop there on the corner of Avenue A and Main Street.
And what did you observe when you were leaving the shop?
Well, as I was grabbing my bag, I heard a screeching of tires, so I looked outside and I saw this Mercury Cougar run right into the back of this smaller black car.
Where were the cars when the impact happened?
Well, they were just right outside of the intersection, and then after the wreck, they were a little further out.
Did you happen to see what color the light was at the time?
Well, after the car stopped, I looked up and noticed that the light was green for both cars.
Thank you, Mr. Smith. I'll pass the witness, Your Honor.
Cross-examination?
Yes, Your Honor. Mr. Smith, you were up late the night before the accident, weren't you?
Yes, I had a program due that Monday morning, so I guess I was up till, I don't know, 3:30 a.m.
And you were at the donut shop at 9:30 in the morning, weren't you?
My grandchildren were visiting me at the time, and when they're there, there's no way to sleep in, no matter how late I stay up.
So that means you were very tired that morning, doesn't it?
Well, I guess so.
And sir, don't you wear glasses?
Sometimes.
Well, do you wear them to drive?
Yes.
What about to read?
No, not to read.
So you're nearsighted, aren't you?
I suppose that's right.
So that means you can't see things from a distance as well without your glasses, doesn't it?
Probably true.
Sir, do you realize that it's 150 feet from the door of the Tasty Cream Donut Shop to the middle of the intersection where that accident occurred?
Well, that's what I've heard since this accident happened.
And you weren't wearing your glasses in the donut shop, were you, sir?
No, but let me tell you, my eyes aren't that bad just yet, and I could see everything that I testified here perfectly clear.
Okay, but you've also testified that you looked at the light after the cars had come to a stop. Isn't that right?
After they came to a stop, I saw the light was green.
Isn't it possible, Mr. Smith, that that light turned green after the impact, but before you looked up at it?
Well, I guess that's possible, yes, sir.
No further questions, Your Honor. I pass the witness.
Call your next witness.
Your Honor, at this time, the defendant rests her case.
Your Honor, plaintiff closes.
Defendant closes, Your Honor.
Ladies and gentlemen of the jury, this concludes the evidentiary portion of this case. It is now appropriate for me at this time to give you additional instructions. After these instructions are given, along with what is called the charge of the court, it will be time for the closing arguments. Plaintiff's counsel may begin closing arguments.
Thank you, Your Honor. May it please the court, ladies and gentlemen of the jury, counsel. When this trial began, I told you that this case was about distractions. Now, you've heard here today about how a distracted Miss Davis slammed her car into Mrs. Payne's car. I also told you that the plaintiff has the burden to prove her case by a preponderance of the evidence. We've done that. Now, Miss Davis does not deny that she was rushing to get to work because she was late. She also doesn't deny that she was on a cellular phone when the accident occurred. In short, Miss Davis was not paying attention while she was driving. And this resulted, and Miss Davis does not dispute this, it resulted in $50,000 in medical bills and $1,800 in damage to Ms. Payne's car. Now, you've also heard Dr. Femer testify that Ms. Payne may never be the same again. And what about the defendant's witness, this John Smith? Well, he was up half the night before the accident, and he could have gotten only several hours of sleep at most. Now, we all know what happens to us when we don't get enough sleep. We're simply not as sharp as we usually are. But what's the kicker? Mr. Smith claims that without the aid of his glasses, a man who's nearsighted, that he could see a light 150 feet away. Now, even assuming that he could see the light, Mr. Smith also testified, you heard him say, that he first looked at the wreck and then looked at the light. So he has no idea whether that light changed before he was able to look at it. Now, Mr. Smith may be a nice guy. I'll grant the defense that. But he's certainly of no use to Miss Davis as an eyewitness. The only witness to that accident that wasn't tired, distracted, or even half blind is Miss Payne. And you've heard her sworn testimony about how the accident occurred. That she was sitting at the light and Miss Davis slammed her car into Miss Payne's car from behind. And that's the best and the clearest testimony you've heard here today, ladies and gentlemen of the jury. And more importantly, it's the truth. In a short while, the court's going to give you some instructions. And you're going to be asked to answer 2 questions. The first question asks whether Ms. Davis's negligence proximately caused the accident. By a preponderance of the evidence that you've heard here today, the answer to that question is clearly yes. The second question that you're going to be asked to answer is about how much money Ms. Davis should have to pay Ms. Payne for her damages. You've heard a number of times now that the medical bills are $50,000 and the car damage is $1,800. Now you, as the jury, are the only hope for Ms. Payne. And we trust that you'll make the right decision. Thank you.
Defendant?
Thank you, Your Honor. May it please the court, counsel. Ladies and gentlemen of the jury, the evidence here today has demonstrated 2 things. First, the accident didn't happen the way Ms. Payne said it did. Second, we can't even be sure that the accident caused Ms. Payne's injuries. The evidence and common sense tells us that the accident wasn't Ms. Davis's fault, and she doesn't owe Ms. Payne anything. First, Ms. Payne didn't even look in her rearview mirror, and she has no idea whether Ms. Davis was stopped behind her before the accident. However, Ms. Davis, under oath, told you that it was only after the light turned green and Ms. Payne started and then suddenly stopped that the two cars collided. And yes, Ms. Davis was on the phone, but she wasn't distracted, and she remembers everything that happened. And here's another thing. She has a witness, Mr. Smith. Mr. Smith corroborated Diane Davis's testimony. He said that he saw the accident. He saw that the cars were in the middle of the intersection upon impact. And what color was the light? Green. Now, Ms. Payne says he was tired and he didn't have his glasses on, so he couldn't see. But Mr. Smith testified without hesitation that he saw the accident and the light was green. And Mr. Smith has no reason to lie to you. So you've heard two explanations here today, Ms. Payne's and Ms. Davis's. Ms. Davis has a witness to back up her explanation. Ms. Payne doesn't. So the preponderance of the evidence on this issue is on Ms. Davis's side. How about this one? It took Ms. Payne count them, 5 days to go to the doctor after the accident. She sat here and told you it was a really bad wreck, and she was really hurt. However, she didn't go to the emergency room, she didn't go to the hospital the next day, or the doctor the day after that, or the day after that. And when she went to the doctor, she failed to tell Dr. Payne that she was a waitress and that she lifted heavy trays over her head time after time after time, and that there were many times she went home from her job with a sore back and neck. Dr. Payne even told you that it's possible that the injuries to Ms. Payne were caused by her job, not the accident. So who do you believe, ladies and gentlemen? Ms. Davis isn't trying to distract you from anything here today. She's trying to get you to focus on common sense. Common sense says a really hurt person goes to the emergency room or a hospital. Common sense says two cars that collide with any amount of force are both badly damaged. If Ms. Davis's car had slammed into Ms. Payne's car, as Ms. Payne testified, there would be damage, more damage, to Ms. Davis's car. Look at the photo. You'd think there'd be some damage that you could see on this picture, but there isn't. Ladies and gentlemen, remember common sense when you look at the court's charge. Did Ms. Davis's negligence approximately cause this accident? Common sense says no. Did this bump cause $50,000 in medical bills and $1,800 damage to Ms. Payne's car? Again, common sense says no. Ladies and gentlemen, did the accident happen the way Ms. Payne said it did? Did such a little bump cause all that damage to her body and her car? The answer to both of these questions is clearly no. Why? Simple common sense. Thank you.
Any rebuttal from plaintiff's counsel?
Yes, Your Honor, thank you. Members of the jury, the defense makes a big deal out of the fact that my client wasn't looking in the rearview mirror when Ms. Davis slammed into her. But why would someone stopped at a red light be looking in the rearview mirror. Ask yourselves that. You'll see it doesn't make any sense. Now, the other thing that the defense makes a big deal about is the fact that they have two people telling their story, whereas we only have one. However, just because they have more people telling their story doesn't mean that their story is true or mean that they have better evidence. I've already told you why you should believe my client and not their witnesses. You have heard Ms. Payne tell you how the accident happened, and it's the truth. We trust that you will answer the questions accordingly. Thank you.
Ladies and gentlemen of the jury, you have heard all the evidence, you have received the court's charge, and you have heard final arguments from both parties. It is now time in the trial for us to turn the case over to you for deliberation and for you to return a verdict. You may now retire to the jury room and begin your deliberations. Has the jury reached a verdict?
We have, Your Honor.
What say you? The court thanks the jury for its time and attention in this case. I remind you that our justice system could not survive unless citizens recognize their responsibility to participate in the jury service. This jury is hereby discharged and court is adjourned.
All rise. The local county court of Texas is now in session. The Honorable Judy Justice presiding.
Thank you. Would the jurors remain standing? I'd like to begin by first saying thank you to each juror for fulfilling your civic duty by serving on this jury. It is your service here today that makes the American legal system the very best in the world. I will now swear you in. Will each member of the jury please raise your right hand? Do you swear or affirm that you will a true verdict render according to the laws as given to you by this court and the evidence submitted according to the rulings of this court? So help you God? I do. You may be seated. We will now take opening statements. Prosecution will go first.
Thank you, Your Honor. May it please the court, counsel, ladies and gentlemen of the jury. On May 15th, the defendant, David Diaz, was arrested for possessing 2 pounds of marijuana. That's a felony in Texas, and we're going to ask you to find him guilty of that offense. Now, as the prosecutor on behalf of the state, I have what's called the burden of proof in this case. I have to prove to you that Mr. Diaz committed and is guilty of the crime charged beyond a reasonable doubt. When you hear all the evidence, I think you'll agree I've done that. On May 15th, Lieutenant John Lee of our local police department received a telephone call from a confidential informant who told him that the defendant was in possession of an unknown quantity of marijuana. Lieutenant Lee drove to the defendant's house, and sure enough, after Mr. Diaz gave him permission to search his car, Lieutenant Lee found a bag containing 2 pounds of marijuana right in the defendant's trunk. You'll find out that the defendant intentionally and knowingly possessed that marijuana. That's a crime in any state, and at the close of evidence, I'll come back and talk to you about the consequences of that crime. Thank you.
Does the defense wish to offer an opening statement at this time?
Yes, Your Honor. May it please the court, counsel, and ladies and gentlemen of the jury. It is my distinct privilege to represent David Diaz. David just graduated from Monroe High School with honors. He was a member of the National Honor Society, he was active in student government, and he was and